Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Azim bin Suhaimi. My number matric is 1251997. So for today, we will discuss about enforcement of Islamic law in civil court. So the key concept is the transition of Islamic law from lex-loci to personal law within a constitutional framework. So what's meaning of the lex-loci? Lex-loci is the law of the place. It is a foundational principle in conflict of law dictating that the substantive right, liabilities and obligation arising from an event dispute are governed by the law of the jurisdiction where the event physically occurred. So, how began the transition of Islamic law from legislative to personal law in Malaysia? It began during the British colonial rules. Its scope gradually become limit to personal matters such as marriage, divorce, inheritance, and religious practice for Muslim only. Within Malaysia constitutional framework, Islamic law recognized under the Federal Constitution and mainly applies to Muslim through the jurisdiction of the Sharia court, reflecting its transformation into a system of personal law. So for now, Islamic law remain legally recognized, but its scope is constitutionally defined. It's applied primarily to Muslim rather than universally across territory. So for now, jurisdiction is divided between civil court and Sharia court. The key issue in Malaysia is the relationship between civil and Sharia court, especially after the constitutional amendment of Article 121(1)(a), which limits civil court interference in matters under Sharia court jurisdiction. Next, we talk about the legal hierarchy. So, what the article we take is Article 4.1 and Article 3.4. For Article 4.1, this constitution, it say that this constitution is the supreme law of the federation, and any law passed after Merdeka Day, which is inconsistent with this constitution, shall, to the extent to the inconsistency, to be void. All law in Malaysia were lower than federal constitution, or we call constitution supremacy. So article 4.1 demonstrate that although Islam is recognized as the religion of the Federation under Article 3.1, Islamic law still operates within the Constitution framework. Therefore, the jurisdiction of the Sharia court and the application of Islamic law must remain consistent with the Federal Constitution. So, for Article 3.4, nothing in the article derogates from any other provision of this constitution. So, the Islam has a special constitution position. However, Article 3 cannot be used to cancel or supersede other constitution right and provision. This means that although Islam is recognized as the religion of the Federation under Article 3.1, such recognition does not override or diminish other constitution provision. Article 3.4 clarified that the position of Islam within the constitution must be interpreted harmoniously with ada constitutional right and provision. It prevents Article 3 from being used to claim that Islamic law automatically supersede the federal constitution, reinforcing that Malaysia remain governed by constitutional supremacy. So, for example, Islamic law is valid only as long as it is consistent with federal constitution.
Assalamualaikum and hi everyone. My name is Diana Ifa and today I am the second speaker. So my part is to explain the famous case of Che Omar bin Cheso and public prosecutor, where the case is very important because it helped our courts to decide how to interpret the federal constitution when it comes to the religions. So the main question was, does the constitution require every law in Malaysia to follow Islamic principles? So to find the answer, we have to look at what happened to two men facing the death penalty. The facts are simple, where two men were convicted of drug trafficking and firearms offences. So in fact, in Malaysia, these crimes carry a mandatory death penalty, meaning that the judge has no choice but to sentence them to death. So the lawyers or the counsels for this man which is convicted did not just argue about the crimes, but they made a big legal argument related to the Article 3 in the federal constitutions, where stated that Islam is the religions of the federations, which is all law in Malaysia must be consistent with Islam. So they argue that because that sentence did not follow Islamic rules for punishment like hudud or qisas, the law was unconstitutional and void. So essentially, they wanted the court to use Islam as the main standard to test if a law is a valid law. What does Islam mean? So this put the Supreme Court in a difficult position where they had to decide what the word Islam means in the constitutions. So does it mean a complete way of life that covers everything, including law, politics, and the court system? Or does it mean something more limited like rituals and ceremonies? Or if it means a complete way of life, then many of our laws would be invalid. If it means rituals, then the secular law made by the parliament would still be valid. To find the answer, the court looked at the history of Malaysia. Before the British came, the sultans were the heads of the religions and politics. Back then, Islamic law was the main law of the land, but when the British arrived, things changed. Through treaties like Treaties of Angkor, the British introduced a system where the sultan's power was split. So the sultans keep control over religions and custom, but the British took over the public government, where this created a separation of legal powers. Religion also became a private matter, while the law for the country became a secular, meaning that they were not based on the religions. So the court explained that during this time, Islamic law was limited only to personal things like marriage, inheritance, and divorce. The court then explained that the people who wrote or who enact our constitution in 1957 knew about this history, where they pointed to Article 162 as a proof. Article 162 stated that all the law we had before independence, which was secular law based on English law, stay valid unless Parliament changed them. So the court stated that if the constitution was meant to make a Malaysia follow only Islamic law, so there would have been a rule saying that any law against Islam is void, but instead the constitution purposely preserved the old secular law. In the end, the Supreme Court ruled that Islam in the constitutions only refers to act, ritual, and ceremonies. So because of this, the mandatory death penalty was declared legal and valid. The judges make a very important point at the end. They said that as a judges, they must follow the law that Parliament has passed, and they cannot use their own religious feelings or personal morals to decide their case. So they explained that until the politicians and parliaments decide to change the system, so the court must continue to apply the secular law of the land. To summarize, this case confirmed that while Islam is the official religion, Malaysia's legal system is a secular, and the constitution is the highest law, and law made by the parliaments are still valid even if they do not follow the Sharia rules. And I will pass next stage to the member Aina to discuss how this affects cases today. Thank you.
Assalamualaikum warahmatullahi wabarakatuh. My name is Aina Safia binti Shamsuddin and my matric number is 1221523. So today I will be discussing the relationship and distinction between the federal and state jurisdiction in Malaysia, where Malaysia operates under a federal system of government, which means that governmental powers are shared between two levels of authority, so the federal governments and the state governments. And this system is established by the federal constitution, which serves as the supreme law of the country. The federal constitution not only creates the structure of government but also determines which matters can be regulated by the parliament and which matters can be regulated by the state legislative assemblies. And this division is important because Malaysia consists of different states with their own local needs and responsibilities. By clearly allocating the powers, the Constitution helps to maintain political stability, prevent overlapping authority, and ensure that both the federal and state governments can perform their functions effectively. And it also protects the rights and responsibility of each level of government. And in addition, the Constitution established separate legal jurisdictions, particularly in relation to civil and Islamic law. So, understanding these divisions is essential to understanding how Malaysia's legal and governmental system operates. So, the division of legislative powers in Malaysia is provided under the 9th schedule of the Federal Constitution, and these powers are divided into the three categories, which is the federalist, state list, and the concurrent list. And the federalist contains matters that are considered national in nature and therefore require uniform laws throughout the country. So Parliament has exclusive authority to legislate on these matters. Example includes defense, foreign affairs, finance, education, citizenship, and civil and criminal law. And since these issues are affect the entire nation, they are managed at the federal level to ensure the consistency. While the state list contains matters that are more closely connected to the individual states, which state legislative assemblies have the authority to make laws on subjects such as Islamic law, land administration, agriculture, forestry, and local government. And this allows states to address their own local circumstances and needs. Then the concurrent list includes areas where both parliament and state legislature may make laws. Examples include the public health, social welfare, housing, and town planning. And these subjects often require cooperation between the both levels of government because they affect both national policies and local communities. So overall, this division of powers creates a balance between the national unity and state autonomy, and it allows the federal government to manage national interests while enable the states to maintain control over matters that are specifically relevant to them. One of the most significant areas under state jurisdiction is the administration of Islamic law. Under the Federal Constitution, Islamic law falls within the state list. As a result, state legislature have the authority to enact laws relating to Islamic matters, provided that those laws apply only to Muslims and remain within the constitutional limits. And in the states, the Sultan acts as the head of the religion of Islam, where the state legislative assembly is responsible for passing laws relating to Islamic affairs, while religious authorities and Sharia courts are responsible for implementing and enforcing those laws. Example of matters governed by Islamic law include the Muslim marriage and divorce, inheritance, maintenance, wakaf, zakat, and certain religious offences. Because of each state has the power to enact its own Islamic legislation, there may be slightly difference in the administration of Islamic law from one state to another state. And this situation is different in the federal territories of Kuala Lumpur, Putrajaya, and Labuan, since these territories do not have state governments or state legislative assembly. So the YDPA or Yang di-Pertuan Agong serve as the head of Islam. So Parliament therefore has the authority to enact laws relating to Islamic affairs in these territories, and this arrangement demonstrates how Islamic law remains a state matter while still being administered effectively in areas that are directly governed by the Federation. Next, Malaysia has a unique legal structure because it operates a dual court system consisting of civil courts and Sharia courts. So, the civil courts are established under the federal law and have jurisdiction over matters such as criminal offences, contract disputes, property matters, constitutional question, commercial dispute, and other areas of civil law. And their jurisdiction applies to all individuals regardless of religion. However, the Sharia court have jurisdiction only over Muslims and deal with matters related to Islamic law. And this includes family law issues such as marriage, divorce, custody, maintenance, and inheritance, as well as certain religious offences created under the state laws. So a key constitutional provision governing the relationship between these courts is Article 1A of the Federal Constitution, and this article states that civil courts have no jurisdiction in matters that fall within the jurisdiction of the Sharia courts. The purpose of this provision is to preserve the independence and authority of the Sharia court system and to prevent jurisdictional conflicts between the two courts. However, it is important to understand that civil courts still play a role when Islamic law becomes relevant in matters that fall under the federal jurisdiction. In such situations, civil courts may ascertain or determine the applicable principle of Islamic law in order to resolve the case before them. And this does not mean that civil courts are exercising Sharia court jurisdiction. Instead, they are merely identifying and applying Islamic legal principles where necessary for federal legal purpose. So, while the civil courts and Sharia court have separate jurisdiction, they are not completely isolated from one another, but the legal system allows for interaction where necessary while still maintaining the constitutional boundaries established by the Article 1A. So, that's all from me. Thank you.
To wrap up, let's summarize how Islamic law fits into Malaysia legal system. First, Article 4, Clause 1 makes the Federal Constitution the supreme law, which means all law, including Islamic law, must stay within the boundaries of the Constitution to be valid. So the Che Omar ruling in the case of Che Omar bin Che So is our key example, where the Supreme Court ruled that Islamic in Article 3 refers only to ritual and ceremonies, not the whole legal systems. This also confirms that Malaysia legal framework is secular in a legal sense. We also see a clear split in power, where Parliament handles general civil and criminal law, while state legislature handles Islamic personal law. Article 121, Clause 1A ensures that civil and Sharia courts do not interfere with each other's specific duties. And in short, Islamic law is an important part of Malaysia, but its enforcement is strictly defined by the Constitution, and the civil courts remain the ultimate guardians of this legal balance. So that's all from us. Thank you.